Today, I'm thrilled to share another exciting thought-provoking video that's going to make waves. A sketch of legal history, Chapter 1. If you're into deep dives into society, equality, and the future, this one's for you. Ever wondered about the foundations of our social fabric? Join me as we unravel the intricate layers of the social contract that shapes our world. Let's challenge our perspectives and explore the implications of its termination. To spread the word, let's start a ripple effect together. Share this video, tag a friend who loves intellectual conversations, and use hashtag #SocialContractUnraveled and at Equity Exposed to join the movement. Let's ignite a dialogue that has the power to reshape our understanding of society. Yesterday's video, Proof, the social contract is finally revealed, contains some of the most complex areas of law within the system of ownership under a king. The focus of these next videos is the history of this system of ownership under a king. The history shows the culture of the different societies, along with the laws of societies before the usurpation of the throne in the year 1066. This same history also shows how each society over time joined one system of law, the English law. History is the only way to see the full structure of the current system. The history reveals the differences between common law and equity. The history created the structure of the system of law. The history also establishes how the law is precise based on a specific procedure, how each law has its own procedure, or set of rules to apply. That law only apply to that area of law. If the procedure is not used correctly, the law cannot be applied to that issue. To help simplify learning the history of the modern system, we will focus on two books, A Sketch of Legal History and A Short History of English Law from the Earliest Times to the End of the Year 1919. The history of law is already categorized based on what was happening at that time. It is far easier to show this than to explain it. Early English law from the year 600 to 1066. The next era in law is English law under Norman rule and the legal reforms of Henry II, 1066 to 1216. The next era in English law is growth of law from Henry II to Edward I, 1154 to 1272. The next era in English law is legal reform under Edward I and the system of writs, 1272 to 1307. The next era in English law is growth of statute and common law and rise of the Court of Chancery, 1307 to 1600. The next era in English law is completion of the common law and statutory reforms after the Restoration, 1600 to 1688. The next era in English law is the supremacy of Parliament and rapid growth of statute law, 1688 to 1800. The next era in English law is growth of statute law and legal reforms in the 19th century. When we take a closer look, there are four main eras in English law and equity. The first era, pre-English law. The second era was despotic law from 1066 till completion of the common law. And statutory reforms after the Restoration, 1600 to 1688. In 1688, the despotic monarchy was removed, and a constitutional monarchy was appointed. The third era, the supremacy of Parliament and rapid growth of statute law, 1688 to 1800, this era allowed constitutional governments to be created. The fourth era, growth of statute law and legal reforms in the 19th century, this last era is the modern system of equity today. Equity is law that is only created by government law based on the grants of the common law. The government position is the same position as the feudal lords had in the despotic system before 1535. The lords made the laws for the subjects, and common law was the law of the despotic king, establishing the king as absolute owner and the people are slaves, until the absolute right to lands was removed by creating a constitutional monarchy. All law books are based on the same main legal writers in history, and the system of English law is already categorized properly. We will review by era in law, using both books, A Sketch of Legal History and A Short History of English Law from the Earliest Times to the End of the Year 1919. Starting with the first era in A Sketch of Legal History and the first era in A Short History of English Law from the Earliest Times to the End of the Year 1919. Looking at both the sources, the discussion by the two scholars on the same topics from a different perspective will help with learning the structure. The scholars did a great job creating a simpler roadmap for learning. Finding the correct starting point is the hardest part. Let's make it easy and fun to learn. I would also like to point out that the modern form of government today did not exist till after the year 1700. This is also why government has nothing to do with the tenure or as defined in modern law, the strict settlement not subject to a trust. For many, the history is the missing link. In this first video, Pre-English Law, the main focus is what system of law is discussed, how each system functions, the difference between ancient and modern laws, and what ancient systems could have influenced the kings in the later era to create the law they did. I also recommend making a chart or mind map. This will help give a visual of the different systems. As you go through the chapters, the visual map will trace the laws, creating a visual diagram of the entire system. That can then be used for the next two parts: structure and procedure. Now let's get through the video. Chapter 1. Early English Law, 600-1066 AD. Legal history. When we speak of a body of law, we use a metaphor so apt that it is hardly a metaphor. We picture to ourselves a being that lives and grows, that preserves its identity while every atom of which it is composed is subject to a ceaseless process of change, decay, and renewal. At any given moment of time, for example, in the present year, it may, indeed, seem to us that our legislators have, and freely exercise, an almost bottomless power of doing what they will with the laws under which we live, and yet we know that, do what they may, their work will become an organic part of an already existing system. Continuity of English law. Already, if we look back at the ages which are the most famous in the history of English legislation, the age of Bentham and the Radical Reform, the age which appropriated the gains that had been won but not secured under the rule of Cromwell, the age of Henry VIII, the age of Edward I, RNHSH Justinian, it must seem to us that, for all their activity, they changed and could change, but little in the great body of law which they had inherited from their predecessors. Hardly a rule remains unaltered, and yet the body of law that now lives among us is the same body that Blackstone described in the 18th century, Coke in the 17th, Littleton in the 15th, Bracton in the 13th, Glanville in the 12th. This continuity, this identity, is very real to us if we know that for the last 700 years all the judgments of the courts at Westminster have been recorded, and that for the most part they can still be read. Were the world large enough to contain such a book, we might publish not merely a biography, but a journal or diary of English law, telling what it has done, if not day by day, at least term by term, ever since the reign of Richard I, and eventful though its life may have been, it has had but a single life. Beyond these 7 centuries there lie 6 other centuries that are but partially and fitfully lit, and in one of them a great catastrophe, the Norman Conquest, befell England and the law of England. However, we never quite lose the thread of the story. Along one path or another we can trace back the footprints, which have their starting place in some settlement of wild Germans who are invading the soil of Roman provinces and coming in contact with the civilization of the Old World. Here the trail stops, the dim twilight becomes darkness. We pass from an age in which men seldom write their laws to one in which they cannot write at all. Beyond lies the realm of guesswork. The first English Code, about the year 600, Thelbert, king of the Kentings, by the counsel of his wise men, caused the laws of his people to be set down in writing. He had just received the Christian faith at the hands of Roman missionaries, and it was an imitation of the Romans that he and his folk desired to have written laws. His reign overlaps the reign of Justinian, and perhaps he had heard how in the far east the Roman emperor had been legislating on a magnificent scale. English law begins to speak just when Roman law has spoken what will, in a certain sense, be its final words. On the continent of Europe the same thing had been happening. No, sooner did the barbarian tribe feel the influence of Rome than it wished for a written code of laws. Ethelbert and his Jutes in Kent are doing what the Salian Franks did a century ago when they wrote down their famous Lex Salica. But while on the continent the laws of the conquering Germans are written in the Latin language of the conquered, in England the barbarians from the first write down their law in the language that they speak, the language which is to become English. Christian influences. Ethelbert's laws have come down to us, though only in a copy made after the Norman conquest. They may seem to us preemie enough. The emperor at Byzantium, could he have seen them, would assuredly have denied that they had any points in common with the Roman law books, save that they were laws and were in writing. Nevertheless, we cannot call them primitive in any absolute sense of that term. They are Christian. Let us look at the first sentence, the first recorded utterance of English law, God's fee, property, and the church's, 12-fold, bishop's fee, 11-fold, priest's fee, 9-fold, deacon's fee, 6-fold, clerk's fee, 3-fold. Churches, bishops, priests, deacons, clerks, these are no archaic German institutions. They are Latin. They have Latin names which must be taken up bodily into the Teutonic speech of the new converts. Unfortunately, so we may now think, Germanic law has no written memorials of the days of its heat Henry. Every trace, but the very faintest, of the old religion has been carefully purgated from all that is written, for all that is written passes under ecclesiastical hands. Thus we may guess that a new force is already beginning to transfigure the wholesome and substance of barbaric law, before that law speaks the first words that we can hear. It is a wild plant that has already been torn from its native soil and set to grow in a garden. The change of faith, and the substitution of one order of religious rites for another, would in any case mean much, for we have reason to believe that the old law had in it a strong sacral element, but as it is, they mean the influence of the old civilized world upon the new barbarian world. Ethelbert's laws consist of 90 brief sentences. 2 will serve as samples. If one man strike another with a fist on the nose, 3 shillings. If the eye be struck out, let boot, i.e., amends, be made with 50 shillings. To call this brief tariff a code may seem strange, but there are not wanting signs that the wise men of Kent are committing to writing as much of their traditional law as they can remember in the form of abstract propositions. No doubt much more law, in particular, a law of procedure, is known to them implicitly. If a concrete case were to occur, they would be ready with a doom, judgment, but when asked for general rules, these 90 are all that they can call to mind. Thus we may say that our legal history starts with an act of codification. This code became the basis of Kentish law. Subsequent kings in the course of the 7th century, Hlother, Edric, Whitehurst, with the Council of the Wise, add some 50 new dooms to the written law of the men of Kent. Then the scene changes to Wessex. The laws of Ione. In the middle of the 7th century, the West Saxons received Christianity. Before its end, they had written laws, the laws of Ione 688 to 726. By the advice of his bishops and of the oldest and wisest men, Ione published a set of laws which tell us a good deal more than we can learn from the Kentish series. Alfred's legislation. The next legislator whose work has come down to us is the great Alfred, 871-901. His laws are divided from those of his ancestor Ione by a period of 2 centuries or thereabouts. This is the one great gap in our continuous legal history. In the history of religion and learning and letters, these centuries are far from being the darkest. They cover the time when Northumbria was for a while a center of light, not for England only, but for the world at large. It may be that we have lost some things. It is fairly certain that Offa, 757 to 96. Of Mercia, in the days of Mercia's greatness, issued written laws. When Alfred is king, when all England. For laws of Ione, about 690, is becoming united under the vigorous princes of the West Saxon house. The 3 legislators whose names are still remembered are Ethelbert of Kent, Ione of Wessex, and Offa of Mercia. From the manner in which Alfred speaks of them and of their laws we may gather that, heavy though our losses may have been, we have lost no document that testified to any revolutionary change in the law. Though near 300 years have gone by since Ethelbert's death, His dooms are still in force among the Kentish people. Alfred tells us that he dared to add but little of his own to the work of his three great forerunners, and though we can see that during the last 2 centuries some new legal ideas have emerged, still the core of the law is what it was. What can be put in writing is for the more part a tariff of the sums that must be paid when deeds of violence are done. The Alfred of sober truth is not the Alfred of legal legend. For the history of law has its legends, the inventive architect of a British constitution, but his laws are the first member of a grand series, the capitularies, we might call them, of the English kings of the West Saxon house. Edward the Elder, Thelston, Edmund, and Edgar, with the counsel of their wise men, legislate in a bold, masterful fashion. For the better maintenance of the peace, they sharpen the old rules and they make new rules. Written law accumulates somewhat rapidly. It is expected by this time that the domesman will be able to find in the Doom Book, the book of written law, judgments apt for most of the cases which come before them. This series extends from the beginning to the end of the 10th century. The laws of Thallard continue it into the 11th century. His laws were many, for he had to say the same thing over and over again. We can see on their face that they were ineffectual. Pie begs and prays men to keep the peace and desist from crime. He must beg and pray, for he cannot command and punish. The Danes were ravaging and conquering, the state tottered, the house of Cerdic fell. Canute. It was left for the mighty Canute, 1017. 35. To bring to a noble close the first great period in the history of English law, the period during which laws were written in the English language, the period which it is convenient to call Anglo-Saxon. Canute's Code we must, if we have regard to the age in which it was issued, call a long and a comprehensive code. It repeats, with improvements, things that have been said before. The great Dane was able to enforce as laws rules which in the mouth of his predecessor had been little better than pious wishes, but it also contained many things that had not been said before. The whole economic and political structure of society was undergoing a great change. If by any two words we could indicate the nature of this elaborate process, we might say that tribalism was giving place to feudalism. Had Canute's successors been his equals in vigor and wisdom, perhaps the change might have been consummated peacefully and by means of written laws which we might now be reading. As it was, there came to the throne the holy but imbecile Edward. Anglo-Saxon justice. The impotence of the growing English state in the administration of justice during the Anglo-Saxon period is thus described by Sir Frederick Pollock. Rigid and cumbrous as Anglo-Saxon justice was in the things it did provide for, it was, to modernize, strangely defective in its lack of executive power. Among the most important functions of courts as we know them is compelling the attendance of parties and enforcing the fulfillment both of final judgments and of interlocutory orders dealing with the conduct of proceedings and the like. Such things are done as of course under the ordinary authority of the court and with means constantly at its disposal. Open resistance to judicial orders is so plainly useless it is seldom attempted, and obstinate preference of penalties to submission. A thing which now and then happens is counted a mark of eccentricity bordering on unsoundness of mind. Exceptional difficulties, when they occur, indicate an abnormal state of the Commonwealth or some of its members. But this reign of law did not come by nature. It has been slowly and laboriously won. Jurisdiction began, it seems, with being merely voluntary, derived not from the authority of the state, but from the consent of the parties. People might come to the court for a decision if they agreed to do so. They were bound in honour to accept the result. They might forfeit pledges deposited with the court, but the court could not compel their obedience any more than a tribunal of arbitration appointed at this day under a treaty between sovereign states can compel the rulers of those states to fulfill its award. Anglo-Saxon courts had got beyond this most early stage, but not very far beyond it. The only way to bring an unwilling adversary before the court was to take something of his as security till he would attend to the demand, and practically the only things that could be taken without personal violence were cattle. Distress in this form was practiced and also regulated from a very early time. It was forbidden to distrain until right had been formally demanded. in Nut's time to the extent of 3 summonings, and refused. Thus leave of the court was required, but the party had to act for himself as best he could. If distress failed to make the defendant appear, the only resource left was to deny the law's protection to the stiff-necked man who would not come to be judged by law. He might be outlawed, and this must have been enough to coerce most men who had anything to lose and were not strong enough to live in rebellion, but estill. No right could be done to the complainant without his submission. The device of a judgment by default, which is familiar enough to us, was unknown and probably would not have been understood. Final judgment, when obtained, could in like manner not be directly enforced. The successful party had to see to gathering the fruits of judgment, as we say, for himself. In case of continued refusal to do right according to the sentence of the court, he might take the law into his own hands, in fact wage war on his obstinate opponent. The Earl, Dorman's aid, and ultimately the King's, could be invoked in such extreme cases as that of a wealthy man, or one backed by a powerful family, setting the law at open defiance. But this was an extraordinary measure, analogous to nothing in the regular modum process of law. Pollock's expansion of the common law, 145-6. The laws of the confessor. In after days he won not only the halo of the saint, to which he may have been entitled, but the fame to which he, Sir Tainley, was not entitled, of having been a great legislator. In the minster that he reared, king after king made oath to observe the laws of the confessor. So far as we know, he never made a law. Had he made laws, had he even made good use of those that were already made, there might have been no Norman conquest of England. But then had there been no Norman conquest of England, Edward would never have gained his fictitious glories. As it was, men looked back to him as the last of the English kings of the English, for of Harold, who had become the perjured usurper, there could be no talk, and galled by the yoke of their French masters, they sighed for St. Edward's law, meaning thereby the law that had prevailed in a yet unvanquished England. Contrast of ancient and modern statutes. Now, these enacted and written laws of our forefathers, representing as they do some 4 centuries and a half, representing as long a period as that which divides us from the Wars of the Roses, will seem a small thing to the first glance of a modern eye. They might all be handsomely printed on 100 pages, such as that which is now before the reader. A session of Parliament which produced no larger mass of matter we should nowadays regard as a sterile session. In the Georgian age, many more words than are contained in the whole Code of Canute would have been devoted to the modest purpose of paving and lighting the borough of Little Pedhampton. It is but fair to our ancient kings and their wise men to say that when they spoke briefly and pointedly. They had no fear that ingenious lawyers would turn their words inside out. God's fee and the church's, 12-fold, they feel that they need say no more than this about one very important matter. Also, we have to remember that life was simple. Men could wish to do, but few things. Our increasing mastery over the physical world is always amplifying the province of law, for it is always complicating the relationships which exist between human beings. Many a modem act of Parliament is the product of the steam engine, and there is no great need for a law of copyright until long after the printing press has begun its work. For all this, however, it is true that these old written and enacted dooms contain but a part of the law which was enforced in England. If we say that law serves 3 great purposes, that it punishes crime, redresses wrong, and decides disputes, and perhaps we need not go into the matter more deeply than this, then we may go on to say that in ancient days the first 2 of these 3 purposes are indistinguishably blended, while with the third the legislator seldom troubles himself. If he can maintain the peace, suppress violence and theft, keep vengeance within moderate bounds, he is satisfied. He will not be at pains to enact a law of contract or of inheritance, a law of husband and wife, a law of landlord and tenant. All this can safely be left to unwritten tradition. He has no care to satisfy the curiosity of a remote posterity which will come prying into these affairs and wish to write books about them. Thus, to take one example, The courts must have been ready to decide disputes about the property of dead men. There must have been a general law or various tribal or local laws of inheritance. But the lawgivers tell us nothing about this. If we would recover the old rules, we must make the best that we may of stray hints and chance stories, and of those archaisms which we find embedded in the law of later days. Folkright. The laws of the folkright law, is one of those words which the Danes bring with them, is known to the men of the folk, but more especially to the old and wise. The free men, or the free landowners, of the hundred are in duty bound to frequent the moot or court of the hundred, to declare the law and to make the dooms. The presiding alderman or sheriff turns to them when a statement of the law is wanted. As yet there is no class of professional lawyers, but the work of attending the courts is discharged chiefly by men of substance, men of thinly ranked percent. The small folk are glad to stay at home. Characteristics of early law. Also some men acquire a great reputation for legal learning, and there was much to be learned, though no one thought of setting it in writing. We should assuredly make a great mistake were we to picture to ourselves these old moots as courts of equity, where the natural man administered an informal law of nature. For one thing, as will be said elsewhere, the law of the natural man is supernatural law, a law which deals in miracles and portents. But then, again, it is exceedingly formal. It is a law of procedure. The right words must be said without slip or trip. The due ceremonial acts must be punctiliously performed, or the whole transaction will go for naught. This is the main theme of the wise man's jurisprudence. One suspects that sometimes the man, who in the estimate of his neighbors has become very wise indeed, has it in his power to amplify tradition by devices of his own. We hear from Iceland a wonderful tale of a man so uniquely wise that though he had made himself liable to an action of a particular kind, no one could bring that action against him, for he, and only he knew the appropriate words of summons. To trick him into a disclosure of this precious formula is a feat worthy of a hero. But formalism has its admirable as well as its ludicrous side. So long as law is unwritten, it must be dramatized and acted. Justice must assume a picturesque garb, or she will not be seen. And even of chicane we may say a good word, for it is the homage which lawlessness pays to law. Fine and composition. We have called the written laws tariffs. They prescribe in great detail the various sums of money which must be paid by wrongdoers. There are pagements to be made to the injured person or to the kinsfolk of the slain man. There are also payments to be made to the king or to some other representative of the tribe or nation. The growth of the system of pecuniary mulcts gradually restricts the sphere of self-help and vengeance. The tie of blood relationship has been the straightest of all bonds of union. If a man of one family was slain by the man of another, there would be a blood feud, a private war. The state steps in and compels the injured family to accept the dead man's war guild, the dead man's price or worth, if it be duly tendered. King Edmund, 945-6, goes so far as to insist that the vengeance of the dead man's kinsfolk is not to comprise the guiltless members of the slayer's clan. The law's last weapon against lawlessness is outlawry. The contumacious offender is put outside the peace. He becomes the foe of all law-abiding men. It is their duty to waste his land and bum his house, to pursue him and knock him on the head as though he were a beast of prey, for he bears the wolf's head. As the state grows stronger, less clumsy modes of punishment become possible. The criminal can be brought to trial and definitely sentenced to death or mutilation. We can watch a system of true punishments, corporeal and capital punishments, growing at the expense of the old system of pecuniary mulcts, blood feud, and outlawry. But on the eve of the Norman conquest, mere homicide can still be atoned for by the payment of the dead man's price or wergild, and if that be not paid, it is rather for the injured family than for the state to slay the slayer. Men of different ranks had different prices. The thane was worth 6 searls, and it seems very plain that if a searl killed a thane, he had to die for it, or was sold into slavery, for a thanely wergild was quite beyond the reach of his modest means. In the 12th century the old system perished of over-elaboration. The bill that a manslayer ran up became in the days of feudalism too complex to be summed, too heavy to be paid, for the dead man's lord, the lord of the place where the blood was shed, and it may be many other lords, would claim fines and forfeitures. He had to pay with his eyes or with his life a debt that he could not otherwise discharge. The influence of Rome. As yet our Germanic law had not been exposed to the assaults of Roman jurisprudence, but still it had been slowly assuming and assimilating the civilization of the Old World. This distinction we must draw. On the one hand, there has been no borrowing from the Roman legal texts. We have no proof whatever that during the 5 centuries which preceded the Norman conquest any one copy of a Roman law book existed in England. We hear faint and vague tidings of law being taught in some of the schools, but may safely believe that very little is meant thereby. The written dooms of our kings have been searched over and over again by men skilled in detecting the least shred of Roman law under the most barbaric disguise, and they have found nothing worthy of mention. That these dooms are the purest specimens of pure Germanic law has been the verdict of one scholar after another. Even the English Church, though its independence may often have been exaggerated, became very English. On the other hand, as Ide said, to become Christian was in a certain sense to become Roman. Whether, had an impassable wall been raised round England in the last quarter of the 6th century, England would not be a barbarous country at this day, that is a question which cannot be answered. As a matter of fact, we had not to work out our own civilization. We could adopt results already attained in the ancient world. For example, we did not invent the art of writing, we adopted it. We did not invent our alphabet, we took the Roman. And so again, to come nearer to our law, we borrowed or inherited from the old world the written legal document, the written conveyance, the will. The written conveyance was introduced along with Christianity. To all seeming, Albert himself began the practice of booking lands to the churches. We have a few genuine land books from the 7th and 8th, many from the later centuries. For the more part they are written in Latin, and they were fashioned after Italian models, but at the same time we can see that those models have been barbarized and misunderstood. The youngish scribes pervert the neat devices of Roman lawyers. Any phrase which draws a contrast between a nation's law and its civilization is of course open to objection. But let us suppose that at the present day a party of English missionaries is setting forth to convert a savage tribe. Perhaps no one of them would know enough of English law to carry him through the easiest examination. And yet they old take with them many ideas that are in a certain sort the ideas of English law. Without being able to define murder, they would know that in this country murderers are condemned to death. They would think that a written expression of a man's last will should be respected, though they might well doubt whether a will is revoked by the testator's marriage. So it was in the 7th century. From the days of Ethelbert onwards, English law was under the influence of so much of Roman law as had worked itself into the tradition of the Catholic Church.